Hi, everybody. I'm Heather Shank with the Division of Planning Community Development. Welcome to our Spring 2025 Planning and Zoning Conference. I'm going to go ahead and get started. We're coordinating three different tracks on three different webinars, the planning, the zoning, and the third track on housing issues. So you are in this one track right now. There's nothing you have to do. It'll be on the whole time. But if you want to switch tracks at some point, you need to log out of this track and sign into or leave this webinar and sign into the new webinar. Um, Again, welcome. Thank you for joining us. I'm going to go ahead and get started. We do have links on these pages. The track sessions after after the webinar today will be recorded and will be put up online, and so these links will be available. You can click on them then. We have past planning and zoning conferences up on the website. You can also access our planning lunches at noon, plan webinar series. And there is an anonymous feedback survey that we have up there, which we always find very useful every year. So please do fill that out after the session is over. Just a little housekeeping this morning. We have some instructions here for how to use the different bars on, just for those who don't do this all the time. You are muted and your video is off. That's how we do these webinars. We ask people if they have questions to put them in the chat, and then we'll pay attention to that chat bar and try to ask the presenters those questions throughout, or we may save them towards the end if we run short on time. Well, maybe this slide should have been first. I already did all this stuff. So as I mentioned, we do have the three tracks that you can access, but you have to log out of one and into the other. Ken Gallagher will be assisting today. I'm moderating up until about lunch, and then we'll have a pass off, and Ken will be moderating the rest of the sessions in the afternoon. We did want to mention our Housing Champion designation applications are open right now. And there's about 2 more weeks, I believe, that the applications will be open. They are online. That is not a competitive process for the designation. The designation allows you to access other funding opportunities here at BEA, and also it allows you to qualify for some other funding in the state at this point as well. We've incorporated it into some other programs. So it is available. As I said, the link will be available after these sessions. And you can contact Leanne Moynihan at the link below if you have questions about that. Just a little bit about our registration this year. This is a map showing our coverage across the state. We're getting quite a bit of the state covered with these registrations, with this information, which we appreciate people logging in and providing this assistance to folks. I can't see, and I hope you can see, I can't see exactly the percentage, but we have been, I believe our registrations were for over 450 this year. Hold on, I think I have to check my chat. Someone is saying they cannot see. What's the chat? Okay, so some folks are saying that they cannot see the slides, but they are being displayed. Okay, thank you. And others have said that it's all right. You might just, whoever's having trouble, want to log off and log back on. So here at the Office of Planning and Development, we provide a variety of services, and I think the main one that ends up being most valuable across the state and throughout the year is the municipal and regional planning assistance. So we collect a variety of information about that. We answer questions. I think that's probably what we're most known for, is assistance with municipal and regional planning assistance. We also have our GIS office, and we coordinate with Granite. We are also working with the St. Anselm's Zoning Atlas to provide information to that resource. And we are the designated state data center We do our dwelling unit survey. We provide that information to the census. Our building permit information we provide to various other agencies. And I know I just went backwards. We are the state region coordinators for the National Flood Insurance Program. So we assist municipalities to maintain compliance with FEMA's regulations for flood insurance. So we provide webinars, other information and assistance. You can reach out to our office if you have questions about flood insurance or compliance with FEMA's program. We also have a variety of other resources. If you go under our resources page, all kind of land use information about transportation, housing, open space, recreation, all that kind of stuff. So our planning lunches at noon, we have those every single month, and we have a different topic every month. Those are accessible through our website as well. You can go straight to that page or the planning webinar page link below, but we've provided you some links to the slides and the recordings for this year's plan webinars. Those are always very helpful and well attended, and we get a lot of positive feedback on those topics. So this is our agenda for today. I'll be shortly passing it off to Cordell Johnson, who will be going over ZBA decision-making process. Then we've got Chris Bolt with the ZBA in New Hampshire. We'll have a short break in between those. Then we will have lunch, and then our NFIP coordinators, Sarah Thunberg and Stephanie Frechette, will be giving a webinar on floodplain variances. And then we'll close out with Chris and Steve Whitley and Cordell ZBA Q&A chat, where you can ask questions, whatever questions you want to ask them. It's there for kind of an open session for discussion. This, as I said, this webinar will be continuously recorded. We won't be turning it off. So we'll just be muting everything and kind of putting up a break screen for those in between times. With that, I got through that pretty quickly. Cordell, are you ready to be teed up and get started? You can take control of the session from me at this point.
Yeah, I'm ready.
Perfect.
If I can find there's the take control button. Okay. So should I begin?
Go ahead.
Okay.
Thank you.
All right. Well, thank you, Heather, and good morning, everybody. I assume if people can't hear me, someone will let me know. I'm Cordell Johnston. I am an attorney in private practice. My practice is limited to representing cities and towns. I do not do anything else. And I was previously with the New Hampshire Municipal Association for 18 years, I think. Retired from that 3 years ago, and now am doing this. And I spend a fair amount of my time representing planning boards and zoning boards. Have been to more ZBA hearings than I ever imagined I would be over the last several years. So I'm going to be talking. Let's see. I need to. I just need to figure out how to advance the slides.
There should be at the bottom of the page a little arrow. For instance, at the bottom of my screen, it says 9 of 195. Yep, there you go.
Oh, okay. All right.
Yep.
There we go. Okay.
Perfect.
Got it. Thank you. Good thing we started early. Okay. So what are we talking about here? Just to be clear, my presentation is about the ZBA process. I'm not going to be talking, at least not very much, about the substantive law that your ZBA deals with. That is what Chris Bolt is going to be talking about in the 10:30 session. So this is mostly ZBA process. The purpose of the ZBA, You may find this hard to believe, but back when zoning first started to become a thing around the turn of the 20th century, uh, there, there were people who were outraged and said, you can't tell me what to do with my property. I have a fundamental right to own and do with my property whatever I want. And zoning is an unconstitutional deprivation of that property right. And through a series of court decisions, including the United States Supreme Court, it was settled that no, zoning is not per se unconstitutional, that states and municipalities do have the right to regulate what people do with their property. Um, but only up to a point. There can be a point beyond which a zoning regulation could constitute a taking of property without just compensation. And so there needs to be, the courts decided early on that there needed to be what they called a safety valve to prevent those kinds of unconstitutional consequences in specific cases. And the mechanisms for that kind of relief are by administrative appeal of decisions, special exceptions, and variances, and equitable waivers, and those are all set forth in the statute. And it is the ZBA that is responsible for deciding whether a particular application of a zoning ordinance to a particular situation would result in an unconstitutional taking, and therefore there should be relief. And so, because of that responsibility of the ZBA, its function is considered a quasi-judicial function. And if you think back to civics class in junior high school, you learned, I hope you learned, I'm not sure how many people still understand this, but there are three branches of government. There's the legislative branch that makes the laws. There's the executive that implements and enforces the laws, and there's the judicial branch. And if you think about say at the federal level, the legislative branch is the United States Congress, and the executive branch is the president and all the departments, the administrative departments, and then the judicial branch is the courts. Not everyone thinks about local government that way, but it is set up the same way. You have a legislative branch, which in most towns is the town meeting. In cities, it's the city council. You have an executive branch, which in most towns is the board of selectmen and the various departments that they manage. And you have a quasi judicial branch, which is the ZBA. It doesn't have general judicial authority. The ZBA doesn't decide criminal cases or anything like that, but it is responsible for deciding land use cases. And in these cases, someone's property is at stake, so you have to be aware of procedural concerns. I want to emphasize, coming out of this session, if you remember nothing else, there are certain statutory requirements that you need to know about, and you need to follow those. You need to follow your zoning ordinance and your rules of procedure. Every ZBA is required to have rules of procedure. Be familiar with those, and obviously be familiar with the zoning ordinance, and base your decisions on the ordinance and those rules and on the applicable statutes. And finally, and maybe most important of all, be fair and reasonable. You are essentially in the role of a judge or a jury, and it is your it is your duty to act fairly and reasonably. A fundamental concept of due process is the right to notice and the opportunity to be heard. And the New Hampshire Supreme Court has said that to ensure that that process works, municipalities have a constitutional obligation to provide citizens assistance with the process. So when someone files an application for a variance or a special exception or whatever it is, the ZBA and your town's land use department have a responsibility to assist them with the process, explaining to them how the process works and enabling them to get their application filed and get into the process. You can't just sit there and wait for them to file their application, and if they make a minor mistake, say, sorry, you're out of luck. You have to provide reasonable assistance. But that doesn't mean you have to help them make their case before the board. That's their job and the job of their attorney if they have one. But you do have an obligation to provide notice and make sure that they have access. So as I said, the ZBA is considered a quasi-judicial board, and you really are acting in a manner very similar to a court. When you have an application, say for a variance or for a special exception, you hear testimony from the applicant and from anyone who is opposed or wants to offer comments on it. You hear that testimony, you gather that evidence, and from the testimony and the evidence that's presented to you, you make findings of fact. You can, to a limited extent, base findings on your own knowledge. So, most of you you're in a town and you have some familiarity with the town and possibly with the property that is at issue in a particular case. And so if you're presented facts that are not true based on your own knowledge, you can rely on your own knowledge to some extent. But for the most part, you should be relying on the evidence that is presented to you and making a decision based on those facts and applying the law to those facts. As in a court case, the burden of proof is on the applicant, the one who is seeking a variance or a special exception, or who is appealing an administrative decision. And so they have to prove their case. And the final bullet point there is that as part of your process, you develop a record that includes the minutes and everything that was presented to the board. You develop a record for possible court review in case someone appeals your decision. I mentioned the requirement of due process, and that is something that it's both a constitutional requirement and requirement that is set forth in various statutes. And the basic components of constitutional due process are that you have to give notice to affected persons of whatever the proceeding is. Affected parties, the applicant and other affected parties, have to have an opportunity to be heard at a public hearing, including appearing and speaking through counsel if they desire. probably the most important aspect of due process is decision by an impartial tribunal based on evidence and facts, not based on your own personal biases. And then there needs to be a written decision with reasons for those decisions and a right to appeal that decision if someone is unhappy with it. That is constitutional due process. Those rights, those due process rights, are specified in particular statutes. I'm not going to go through those here, but you ought to become familiar with those statutory requirements as part of your responsibilities on the ZBA. So they're set out on that slide. In your work, you will almost inevitably have to deal with other boards, or at least be aware of what other boards, especially the planning board, are doing. There are a lot of situations where if someone wants to develop their property in a certain manner, they're going to require approval by both the ZBA and the planning board. For example, someone wants to put in a convenience store on a particular property, and that use is not permitted on that property under the zoning ordinance. So they're applying for a variance to be allowed to develop that property. If they get the variance, then they are also going to need site plan review. If your municipality is one where the planning board has site plan review, most towns do have that. So this applicant is going to need approval by both the ZBA and the planning board. And the question comes up, well, which board should go first? Should they apply for site plan review to the planning board first, or should they apply for a variance first? And there's no right or wrong answer to that. Although in my view is that in most cases, it probably makes more sense to go to the ZBA first, especially if you're seeking a variance, because if the ZBA isn't going to give you a variance, then there's no point in doing site plan review. And site plan review is typically a more involved, it's a more technical process. It can involve a lot of review of plans, and so take a fair amount of time and a fair amount of expense. And you don't want to put an applicant to all that time and expense if they go through that and they get site plan approval, and then they go to the ZBA and says sorry, and the ZBA says sorry, no variance. So I think when I've had this issue, I've suggested that they apply for the variance first. But again, that is not required. You can do it either way. And there is the option of having joint meetings. RSA 676-2 says that any land use boards, any two land use boards can hold joint meetings to decide a case where both boards would have jurisdiction. So if you have someone who's applying for, who needs a variance and site plan review, you can hold a joint meeting of the ZBA and the planning board, and get all of the evidence, all of the testimony, all of the facts out on the public record, and then have each board make its decision. I have not dealt with that very often. I did many years ago when I was on the Henniker Planning Board. We did have one case where the planning board and the ZBA held a joint hearing, and it worked well. So that is an option. It can be a little tricky, but it is worth considering when you have something that requires approval by both boards. I should say I'm not monitoring the chat. It looks like
there haven't been any content related questions, but if
okay.
we'll try to jump in and share them with you when they when they're there, or we'll save them for till the end.
Okay, good. One, and I said I'm not going to talk about substantive law, but one court decision, one doctrine that you should be aware of is what I think all land use attorneys refer to as the Fisher v. Dover doctrine. And that is a rule that says that that an applicant can't keep applying for the same thing over and over. If they get denied the first time, they can't apply again a second time. And you can imagine how this might happen. I want to do something with my property. It's not permitted by the zoning ordinance, so I apply to the ZBA for a variance, and the ZBA denies it. And then a year or two later, the composition of the ZBA changes, and I think that the new board is going to be more friendly to me than the old board was, so I go back and apply for exactly the same thing. The New Hampshire Supreme Court has said you can't do that. The ZBA shouldn't, if that happens, the ZBA shouldn't even hear the case. It should be denied because there needs to be finality in land use decisions. And once something is decided, it is decided. That can be, there is not an exception to that, but if the application is materially different from the previous application, then the Fisher v. Dover doctrine doesn't apply, and you can hear that again. Or perhaps there's been a change in the law that would allow that makes the case different. But it has to be either the facts have changed, the application itself has changed, or the law has changed, not simply that the composition of the board has changed. So, for example, say your zoning ordinance has a height limit for certain structures of 30 feet, and someone applies for a variance. They want to put in a structure that would be 60 feet tall, and the board concludes, no, that's really extreme. We're not going to allow that. But the board says, well, if it were 40 feet, we might grant that variance. But no way that we could grant a 60-foot a variance for a 60-foot structure. But they make it very clear that 40 feet would fly. So the applicant comes back a month later and applies for a variance for a 40-foot structure. That would be a materially different application, especially because the ZBA has said that they would consider that. That's the kind of case where you can do it. But if it's exactly the same as the original, you should not hear that. As I say here, a denial without prejudice, and that would be sort of what I just described. We say we're not going to let you do 60 feet, but we're going to deny this without prejudice if you want to come back with an application for 40 feet. The court has said that the Fisher v. Dover doctrine can't be used offensively. There was a case where an applicant had previously received approval for something. I don't remember whether it was site plan approval or a special exception or what, but they got approval from a local land use board to do something. They never did it. They never developed the property. And 3 or 4 years later, they came back and said, well, we never developed this property. Now we want to do it. So we just want you to rubber stamp our application. The Supreme Court said, no, you can't do that. You have to start over with a new application. So
Cordell, we
yes.
have had a few good questions in the chat that I'll share with you. The first is, what do you think about planning boards giving approvals with the condition of an approved ZBA, a ZBA approval?
Yeah, that's fine. the planning board certainly can do that. I mean, if it requires ZBA approval, that's kind of implicit anyway. But it's certainly okay for the planning board to have that as an express condition of their approval.
And there's another question that seems similar to what you just answered. What if the variance expired, but the application is similar? Do you have to grant it again? Seems like you're saying no, you do not.
No, correct. You do not. If it has expired, they have to come back and go through the process again.
And the last question we have for right now seems like has more to do with whether ZBA members have to be in person or whether they can be remote. This question is, does that mean ZBA member, you said the applicant has the opportunity to appear before the ZBA. Does that mean the ZBA members need to be there, or can they just join by phone?
They subject to limitations, they can participate remotely. That's a right to know law question, and I won't get into it in detail here, but they're under the right to know law. If you have a situation where someone can't be physically, a board member can't be physically present, the board can allow that person to participate by phone or by video conference or in some manner so that he or she can hear what's going on, and also that that he or she can be heard when they speak. As I say, there are limits on that. You have to have a quorum of the board physically present. All votes have to be by roll call, and there's certain other, as I said, I'm not going to get too much into the detail, but the short answer is yes, you can allow someone to participate remotely. I would say that is not an ideal situation, because frequently the applicant is going to have a presentation that may involve, plans that they're putting out on the table for all of the board members to see. And if you're participating by phone, you're not going to be able to do that. So it's difficult logistically, but legally, yes, it can be done.
Great. So we're getting more and more questions, which is excellent. I'm going to try to let you progress with your presentation and then save some of these for the end, just so we make sure you may answer some of these throughout your presentation. And
Yep.
We want to make sure that you are able to get through all your slides. So we'll come back to some of these questions, but these are great questions. I'm really glad people are engaged in asking them. So, but go ahead and let's try to get through a few more of your slides.
Sounds like people are still awake. So that's
exactly. Good job.
So let's start with the application. And again, most of the time you're dealing with either an application for a variance, an application for a special exception, or maybe an appeal from a decision of, say, the building inspector or the code enforcement officer. It is good to have an application form, and the towns that I represent, I think all of them have this form, where they have one section that you can fill out if you're applying for a variance, another one that if you're applying for a special exception, another one if you're appealing an administrative order, another one for an equitable waiver. And so it's good to have that form that asks the applicant in the application form to address the specific elements that they need to prove in order to get the relief that they're asking. So, for example, if they're seeking a variance, there are 5 criteria that have to be satisfied that they have to prove to get a variance. There's the public interest, there's the spirit of the ordinance, there's the hardship, no effect on neighboring property values, etc. And the form that I've seen lists those 5 criteria and asks the applicant, how are each of these criteria satisfied? So the more you can put in your application form to guide the applicant to get into the process adeptly is the more you can do that, the better. So someone has filed an application. There are timing requirements. You have to, the ZBA has to hold a hearing within 45 days of receipt of the application. If you don't hold a hearing within 45 days, what happens? Well, there's no clear answer to that. The Supreme Court has said failure to hold a hearing within 45 days doesn't mean the applicant automatically gets what they've asked for. But you really do need to hold that hearing within 45 days. The applicant can waive that, and frequently there are reasons that it makes sense to do that. I have a situation that I'm dealing with right now where someone applied in December, so the 45-day period would have expired around the end of January, and we have a hearing scheduled for next week because there were for various reasons involving both the applicant and the board, it wasn't possible to do it, and the applicant agreed to continue to postpone the hearing. So that can be done. If for whatever reason you can't hold the hearing within 45 days, you can ask the applicant to waive that requirement, but they don't have to. The law also says that the ZBA has to approve or disapprove the application within 90 days after receipt. That's after the application is filed, not 90 days after the hearing. Again, that the applicant can waive that. If you're approaching 90 days and you haven't received enough information that you think you can make a competent decision, you can say to the applicant, give us an extension, please. And if they say no, you can say, well, then we're going to deny your application because we don't have enough information, but it's a denial without prejudice. So they can come back later, and the Fisher v. Dover doctrine would not apply because you denied it without prejudice. They can come back later and give you the additional information that they need. But in that situation, usually if the board says we need more time, the applicant will agree to more time because that's easier than having their application just rejected. You have to give notice of the hearing to interested parties, and that's by certified or verified mail at least 5 days before the hearing. It's a fairly short notice requirement. It has to go to the applicant, has to go to abutters, and it has to be published in a newspaper of general circulation at least 5 days before the hearing. As I say at the bottom here, you can always provide more notice, but not less. You can notify more than just the abutters if you want, or you can publish it in 2 newspapers or 3 newspapers, but you can't do less than the requirement. One of the issues comes up all the time is whether the applicant has a right to a full board. The board consists of 5 members, and I'm sure many of you have dealt with this situation. You can only get 4 members present for a meeting. What do you do? Does the applicant have a right to insist on a full board? The answer is no. The applicant doesn't have an absolute right to have a full board present, but as you can imagine, they probably would prefer to have a full board because they need the affirmative vote of at least 3 members to get what they want. And if there are only 3 members present, that means they need a unanimous vote. If there are 5 members present, they still only need 3. 2 people can dissent, and they could still get it. So usually the applicant wants a full board. And what most boards will do is if they don't have 5 members, they'll say to the applicant, we only have 3 or 4 members present. Do you want to postpone until we can have 5? and just leave it up to the applicant whether they're willing to go ahead with less than a full board. If you do that, you should make that option available in every case, not not randomly to whoever you want. Other questions are whether you can substitute someone after the process starts, and whether a member can vote if he or she missed one or more sessions. So say you have a pretty complicated case and your hearing extends over 3 or 4 meetings, and you have one member who wasn't there for the first 2 meetings, but then is there for the last meeting or meetings. Can that member participate? The court has said yes, if that member becomes familiar with what has happened up to that point. So if they read the minutes and they read the stuff that was submitted, if there's a recording, they listen to the hearing so that they can get up to speed. Yes, they can participate. And if you have someone who was present for the first couple of hearings but then is absent, can you substitute an alternate member? Again, the answer is yes, subject to the same condition, that person can become familiar with what has happened and catch up. Of course, it is ideal to avoid that situation if possible. So you have your public hearing. The participation by the board in the public hearing, the board members should ask questions. You shouldn't just sit there and let the applicant present their case and then let others present their cases. Surely you're going to have questions, and it is appropriate to ask those questions as you go. Your ZBA probably has a few alternates, and one of the questions that come up is, can the alternate, even if the alternate is not actively sitting in place of someone, so you have a full board and then you have 2 alternates there also, can they participate in the hearing process? Can they sit up with the board and ask questions? And the answer is, if your rules of procedure provide for that, then they can. And I think it's kind of a good idea. Not everyone shares that opinion. But I think it's a good idea to have your rules say that alternate members can participate even when they're not voting. So they participate in the hearing, they ask questions, etc. But then when it gets time to vote, the alternates don't vote unless they're actually sitting for someone. If you have a disqualified member of the board, say one of your board members is in a abutter to the property in question, and therefore they have to be disqualified, which I'll talk about later, that member has the right to participate as a member of the public. So that person goes out, sits in the audience, and can come up and speak for or against the application. The board has to hear all parties. Again, that would be the applicant and any abutters. And it can decide to hear other people as well, even if they don't have a direct interest in the application. But again, that's a rule that you ought to apply evenly as well. So I said I would talk about disqualification, sometimes referred to as recusal. This is very important and frequently disregarded. As I've said several times, your job is to be impartial. The applicant has a right to a fair hearing by people who are impartial and are not prejudiced. And there are statutes that govern here. RSA 673-14 says that a member is disqualified if they have a direct personal or pecuniary interest, or if they would be disqualified to act as a juror in the same matter. So that's what we refer to as the juror standard. I'm sure many of you have been called for jury duty, and the judge may have asked you questions like the ones that are set out here. This is RSA 50A12, and which says that a judge can ask a potential juror whether that person expects to gain or lose from the decision, is related to a party, has advised a party, has formed an opinion, is employed by or employs a party, is prejudiced to any degree regarding the case, or employs counsel appearing in the case. And then it says that a juror will be disqualified if he or she, quote, is not indifferent, end quote. So that's the standard that you have to apply in deciding whether a member needs to recuse him or herself, and whether you need to recuse yourself specifically. You have to think of it as a jury trial, where someone is accused of murder, or where it's an automobile accident or whatever. And if you have a strong opinion about that case, you've been watching the news, and you walk into the jury room thinking, well, I know that guy's guilty because of what I saw on the news. You can't be a jury in that case. You have to be impartial. Similarly, if you have a case before the ZBA and you say the applicant and you think that guy's a crook, I went to high school with him, he's a jerk, he stole my girlfriend when I was in high school, and I'm going to make sure that he doesn't get what he wants. You cannot do that. You must recuse yourself and not participate in that case. I had a case about a year ago where it became clear during the hearing that the person, actually the chairman of the board, and I'm quite sure no one from that board is here today, but it became quite clear during the hearing that the chairman did not like the applicant, and there were strong feelings, and the chairman actually had done significant research outside of the hearing process, and basically acted as a prosecuting attorney during the course of the case. He should have disqualified himself, and in retrospect, I think I should have intervened and had a private consultation and said, you are clearly biased and should not be involved in this case. I didn't do that. I think that was a mistake. Fortunately, the decision was not appealed. But if it had been appealed, or if you have a case where a member of the board participates when he or she clearly should not have been participating, and the board reaches a decision, there's a good chance someone's going to appeal that decision. And if the facts make it clear that that person should not have been participating, that decision is going to be reversed. It doesn't matter whether it was a unanimous decision. It doesn't matter that one member. It doesn't matter whether that one member was the deciding vote. Just the fact that he or she participated, that poisons the decision, and the decision is going to be reversed. So my advice is, if you have a strong opinion and you know how you want this case to be decided, the best thing for you to do is recuse yourself, because if you participate and you help to decide the case the way you want it to be decided, that's going to be appealed and it's going to be reversed, and you're going to get the opposite result of what you wanted. You should recuse yourself. You should go sit in the audience, and then you have a perfect right to speak as a member of the public. Sorry for the lecture, but this is very important. Now, there is a process, a disqualification process under the statute 674 or 673-14. There's a process. If it's unclear whether someone should recuse him or herself, any board member, including that member, can ask the board to vote on whether they should be disqualified, and they'll take a vote. That vote is not binding. So if I'm a member of the board, I can say, I can ask the board to vote on whether I should be disqualified. And the rest of the board votes unanimously, yes, you should be disqualified, you should not participate. I could still say, no, I'm going to participate. But the problem with that is if everyone thinks that I'm prejudiced, they probably have a reason to think that. And so if the entire board votes that I should be disqualified, I probably should disqualify myself. Now back to the public hearing. I've described the process generally. You're there.
Cordell,
yes.
we do have a few questions that might be appropriate to ask right now. I'm not sure if you cover them in the rest of your session, but one of your last few slides said that the board may hear such other persons as it deems appropriate. And the person is asking, am I correct that this is the chairman's decision? And then there was another question about how do we deal with people who we feel have no standing related to the case? So I'm not sure if those are two sort of related questions.
Yeah, you should have, I think, first of all, you should have a consistent rule on this. The people who are entitled to be heard are basically the people who received notice. But you can decide to let others speak, and most of the boards that I've seen in action will generally let other people speak, and it's not really a huge burden, but you don't have to, and that really is up to the board. Does the chairman make that decision? I'd say in the first instance, yes. But the chairman is not a dictator. If the chair says I'm going to let these other people speak, and the rest of the board thinks they shouldn't be allowed to speak, I think it's appropriate for someone to make a motion to not allow those people to speak, and then let the board vote on. Vote by majority. But again, you should have a consistent practice, not in one case let the entire world speak, and in the next case let only the applicant and the abutters speak.
So with the question on how do we deal with people we feel have no standing, how would you guide them?
That would be the decision. The chair can say
they don't speak.
Yeah, we're not going to allow you to speak. And then again, if the board disagrees, they could overrule him.
Yeah.
Him or her.
And then one last quick question here. If a member, which I actually don't entirely understand, so this person might expand. If a member asks for a vote about recusal and the board says no by a vote, but there's still, I understand, but there's still an obvious conflict. In other words, what if the board determines there's no conflict, but it's obvious to everyone else that there is a conflict?
Yeah, well, again, as I say, the vote is non-binding. But if there's an obvious conflict, if it's obvious to you and you're the person, then you better recuse yourself. If the board has voted no, then apparently it's not obvious to the board. So that board vote is advisory only. I will say the fact that the board has determined there's no conflict, that would not prevent a court from subsequently saying, well, the board was wrong. Clearly, you've had multiple run-ins with the applicant over the years, and clearly you have a conflict, and you should recuse yourself.
Great, thank you.
Okay. Frequently, the hearing, there's so much information or so many people want to talk that you can't get the hearing done in one day. You start your hearing at 7 and it's 11 o'clock. You're not required to continue until 3 in the morning. You can continue the hearing to another day, and you should. People shouldn't be making decisions at 1 or 2 o'clock in the morning, I think, for the most part. And so you can continue the hearing. If you're going to do that, you should state before you recess. You should state the date, time, and place of when the continued hearing is going to be held. And if you do that, you don't have to provide new notice of that hearing. You should make sure that in between there is no discussion between the parties and the board, and no discussion among members of the board, at least as to the substance of the hearing. You can talk about scheduling and who's going to be there, et cetera, but you should not be talking about the substance of the case in between. One thing that can happen is maybe you close the hearing on the first night and you say, okay, the hearing's over, but we need time to deliberate, and we don't have time to do that now, so we'll do that at our next meeting in 2 weeks. The next meeting comes along in 2 weeks, and you decide, oh, there's additional information that we want, so we're going to reopen the hearing. That's a bad thing, because if you said that you're closing the hearing, people will assume the hearing is closed and there's no more opportunity to offer evidence or testimony. So you should not reopen the hearing, or if you're going to do that, you should provide new notice. You need to make sure before you close the hearing that you have received all of the evidence and testimony, and all of the questions that you have been answered. So I think probably the better thing to do is, rather than close the hearing at the end of the first night, if you're going to recess and deliberate 2 weeks later, I'd say leave the hearing open until the next meeting 2 weeks later, then continue the hearing. If you don't need any more information, you can close it then and then go into deliberation. Frequently, you may need legal advice either before or during a hearing or after a hearing. If you need to do that, you should consult with your town attorney, assuming that you have authority to spend the money. Check with the powers that be, I suppose, before doing that. But the ZBA or any board can consult with its attorney in private. This is not considered a non-public session under the right to know law. It's considered a non-meeting, and so it is totally exempt from the right to know law. And I've had this happen frequently. The board is in the middle of a hearing, or more typically, they have closed the hearing, and now they're deliberating, but they have questions. The board and I will go off into a separate room, and they'll ask me their questions, and I'll advise them. You should feel free to do that, again, assuming that you can spend the money on your town attorney. It is better to get those questions answered before you make a decision rather than after you make a decision. You can review legal advice without the attorney present. If your attorney has provided legal advice, say in the form of a letter or an email to the board, you can go into a non-public session to discuss that, even though the attorney is not present. But the better situation is to have the attorney present, either physically present or available by phone, and then you can just recess the meeting, have your consultation with legal counsel, and then go back into your meeting. So the hearing, you have received all the evidence, all the testimony you need. You then go into deliberation. That, as I said, you might get to, it might be 11 o'clock and you've closed the hearing. You don't want to deliberate then, so you continue it to a different day. And again, if you need to get legal advice before that, you do it. Understand that you can deliberate only in public. Many years ago, my first introduction to land use processes, in my own town, I saw the planning board would hold a hearing and then they would go into the back room and deliberate. You can't do that. Clearly cannot do that. That it must be done in public. But no notice is required, other than no personal notice is required for that, because it's not a hearing. It's just if you're at the deliberation stage, it's just a meeting. So it's subject to the same notice requirements as any public body meeting under the right to know law, but you don't have to send the certified mail and publish in a newspaper like you do for the hearing itself. Once you go into deliberation, it should be only the board members. Then again, that can include the alternate members if your rules allow for it. You should not ask questions to the applicant or anyone else during deliberations, because if you do that, you're essentially going back into a hearing. If you need to do that, you should reopen the hearing. And as I mentioned before, that has its own problems. So once again, try to get all of your questions answered before you close your hearing and go into deliberation. Make sure that your minutes, to the extent possible, reflect the deliberation, the discussions that people have, the questions they ask, the board members ask, and the opinions that they express, because those minutes could become very important if the decision is appealed. And the process of deliberating, make sure you understand what relief is being sought. I've seen meetings where you get to the end and of the hearing and you go into deliberation, and one of the board members says, "So is this a variance or a special exception?" You shouldn't have that question at that point. You should have understood that from the beginning. But if people are confused, just make very clear, this is an application for a special exception, and these are the standards that apply. And you go over those standards and discuss how the evidence that you've received fits with those standards. What are the facts, and what facts support the standards that need to be established, or what standards weigh against those, or what facts weigh against those standards. Frequently, you will hear.
Cordell, can we have to go to a little break for a few questions? Okay. One of them was, to what extent does a ZBA decision constitute a precedent with regard to future ZBA decisions? I've seen this a lot too. They'll say, "Oh, well, last time this happened, we did this, and so we have to do this again, or we're not being consistent." What are your thoughts on that?
It does not. It is not binding precedent. I mean, every case is different, and so a ZBA decision does not establish any kind of legal precedent, but you need to be consistent in how you make decisions. If you have two cases that are very similar, and you decide one way and the other the exact opposite, that could be subject to challenge. So I would try very hard to be consistent, but legally it is not a binding precedent.
Great. And the last question is, does deliberation exclude the attorney?
Uh, well, the anyone can be present, whether it's the attorney or any member of the public. Anyone can be present. Uh, can the attorney participate in the deliberations? I mean, if the attorney is offering legal advice, sure. Although if I'm offering legal advice, I don't want to be doing it during deliberations. I want to be doing it in private. Because if I tell them, here's what you should do, and I've had this happen, um, if I tell them you should do this and then they do the exact opposite, that's not going to look very good when the case gets appealed. So I would, I mean, the attorney can be present, and if the deliberations sort of start to go off in the wrong direction, the attorney can kind of gently guide them back to the topic, but should not be really offering significant legal advice during public deliberation.
Right. And this is an interesting one. Can a board grant relief other than what was requested? So in other words, if an applicant requests the wrong relief for the wrong section, or, can the board grant a special exception if a variance was asked for, or relief from another part of the ordinance that they didn't request?
I think the answer to that is generally no. If someone's applied for a variance and in the middle of the hearing, the board says, "Oh, you don't need a variance. We can grant a special exception here because we think you meet all the criteria." The problem with doing that is that the public and the abutters have only been notified of a variance application. And if I'm the neighbor, I might look at that and think, "Oh, there's no way they'll ever get a variance, so I don't need to worry about that." And then if the board instead says, "You don't need a variance, you just need a special exception, we're going to do that," you haven't given proper notice. So if that comes up, then I think you need to start over.
Right.
One thing that could happen is someone applies for a variance, and then you get into the hearing and you realize they don't need a variance. What they're doing is permitted. I mean, that shouldn't happen, but I have heard of it happening. And if they don't need a variance, then you just say you don't need a variance. Maybe they still need a special exception, in which case you say go back and apply for a special exception.
Yeah, and this person had a follow-up question whether you could, excuse me, put on the public notice that the board, can you state or grant such other relief as the board deems necessary on the public notice? And I imagine that would be a no. You'd have to state probably the specific relief requested on the public notice.
Right. Yep.
Yeah, thank you.
Okay. I enjoy answering the questions, although I think I may have to rush through some of my slides. So you will.
I'll hold the rest till the end.
Okay. Well, I'll do this as quickly but as thoroughly as I can. You likely will receive some expert evidence during a hearing, whether it's an environmental engineer talking about what the effect on wetlands is going to be, or it's a realtor talking about the effect on property values. The court has said that you have considerable discretion in weighing expert testimony, and in particular, if you hear from two different experts who have different opinions, you can choose to believe that one is more credible than the other. If you have one expert saying something and there's no expert opinion disagreeing with that, you should be very careful about simply rejecting that opinion, because expert testimony, I mean, they are experts. And if an environmental engineer gives you a very comprehensive analysis and you know nothing about environmental engineering and you say, I don't agree with that, and the board just rejects that testimony, there's a good chance that decision will be reversed on appeal. So consider expert testimony, and again, you do have some discretion, but you you can't simply reject it because you feel like it. So you're through your deliberations. Someone needs to make a motion to do something. So follow your rules. I emphasize here, Robert's rules are not required. No land use board in New Hampshire should be trying to follow Robert's Rules of Order, which are about 700 pages and almost nobody understands them. One of the questions I asked here is, can a member draft a motion ahead of time? Yes. If you've had the hearing on night one and you're ready for deliberations on night two, if you think you have formed an opinion at that point, yeah, sure, you can draft a motion going into deliberations. You do not circulate it in advance because you should not be discussing this with your fellow board members outside of the public meeting. You can, frequently someone makes a motion and then someone else wants to amend it. And you can get bogged down in amendments to amendments. Just be very careful, keep track, try to have only one amendment at a time, so that it doesn't get too confusing. And when you're drafting a motion, understand what the applicant has asked for. You're not required to just say granted or denied. You could say, and you go back to my example of a variance for a 60-foot structure. Maybe during the course of the hearing, the applicant has heard the objections and said, okay, I would accept a 40-foot structure. You can have a motion that grants a variance for a 40-foot structure instead of the 60 feet. You can include conditions in your motion, and that is very common. The minutes have to indicate who made and seconded the motion. Make sure the motion is very clear. Have it in writing so that there's no question about exactly what the motion was and what the decision was. If it's being recorded, make sure that everyone can hear and understand what's being said. Boards frequently impose the two kinds of conditions. Conditions precedent, those are conditions that have to be fulfilled before an approval is final, such as obtaining site plan approval from the planning board. Or the other kinds of conditions are conditions subsequent, and those are conditions that restrict, they're a limit on your decision going forward. I use the example here of hours of operation. Yeah, we'll grant your variance to have a convenience store, but you can only be open from 7 a.m. to 10 p.m. or whatever. Or you will grant your special exception, but only if your dumpster is behind a 10-foot stockade fence or whatever. You'll be able to read all this stuff afterwards, so I'm gonna go through here kind of quickly. It should be understood that land use approvals and conditions run with the land, not with the owner. And you cannot, you can try, but it won't be enforceable. You cannot put a condition on a variance or a special exception saying this is good only so long as you, John Doe, applicant, own the property. If you sell it to someone else, the variance goes away. You can't do that. And so that's important to understand when you're granting a variance or a special exception. Don't do it just because you think it's a bad idea generally, but you think this particular owner will do a good job, because once this particular owner goes away, the approval is still there. The law says that you have to have at least 3 concurring votes to take any action. So if you have 3 if you have only 3 members present, a 2-to-1 majority doesn't work. You have to have 3 concurring votes. The question that lawyers discuss all the time is, if you don't get 3 votes in favor of a motion, is that a denial or is it simply a non-decision? There's no clear answer to that. So someone's applied for a variance, and one of the board members makes a motion to approve the variance, and the motion fails 1-4. Is that a denial of the variance, or is that simply a non-decision? Do you now need a separate motion to deny the variance? In most cases, if the split was 1-4, someone now makes a motion to deny the variance, and it's probably going to pass by a vote of 4-1. But you can have situations where you can't actually get a majority, or you can't actually get 3 votes to approve or to deny. I say here, your rules of procedure should address this question. It's a difficult one, and you might be prepared to ask your town attorney what to do in that kind of situation. Chris Bolt, I am sure, is going to talk at length about variances in the 10:30 session, but just very briefly, there are 5 criteria that have to be satisfied to grant a variance. And you have to, there have to be at least 3 members voting in the affirmative to grant a variance. There are varying opinions on whether you should vote on each criterion separately, or whether you should discuss them separately, but then just vote on the decision as a whole. My preference is discuss all 5 criteria and then just have one vote to grant or deny the variance. But as I say, there are differing opinions on the best approach. The law does say that if you're going to use whatever method you use, you have to use that consistently until you formally vote to change that method. It's kind of a weird law, but there it is. A written notice of your decision is required by RSA 676(3). You can't just have a record of the decision in the minutes. So it is very important that you actually have a written notice of decision that is provided to the applicant. That decision has to include, or should include, the motion that was passed. If the application or the appeal was denied, the decision must explain the reason for that denial. It should include all conditions, and it must include specific findings of fact that the decision is based on. Okay, that written decision and the meeting minutes have to be available for public inspection within 5 days after the vote. If they're not, that is a technical violation of the right to know law. And if they're not, as far as an appeal, it's not a disaster, but it does give the applicant or whoever is appealing additional time to amend their appeal if they do appeal. You make a decision. Someone doesn't like it. Either the applicant or an abutter doesn't like the decision. They have a right to file a motion for a rehearing. And in fact, if they want to appeal the decision to the Superior Court, they have to first file a motion for rehearing. And that motion has to be filed within 30 days after your decision. The applicant can file a motion for rehearing, or an abutter. And interestingly, the select board can file a motion for rehearing. I've had that happen. You wouldn't think it would be that common, but I have had several cases where the select board didn't like the decision of a ZBA, and so they filed a motion for rehearing and then ultimately appealed to the Superior Court. So yeah, they have 30 days to do that. If during that 30-day period, something comes to the attention of the ZBA and they realize, oops, we made a mistake, the ZBA can, on its own motion, decide to reconsider a decision. If someone files a motion for rehearing, it has to include every reason that they believe that the decision was unlawful or unreasonable. Then, if you receive a motion for rehearing, you have to grant or deny it within 30 days of the filing of the motion. You hold a public meeting, not a hearing, a public meeting to decide whether to grant the rehearing. And the way that works, the way I've advised boards to do that is, you have the motion for rehearing in front of you. Someone on the other side may have filed an objection to the motion for rehearing. That motion is supposed to contain all of the reasons that your decision was wrong. And so you make your decision based on what has been filed and based on your own discussions. You do not hold a public meeting. You don't reopen it for discussion with the applicant or the abutters. You discuss and vote. The board just discusses and votes, yes, we will rehear this, or no, we will not rehear this. And your decision should, ideally, again, what I recommend is the decision should simply be granted or denied. You can grant the rehearing to correct a mistake if you realize that you applied the wrong standard, or you relied on facts that clearly were not correct, or whatever. You can grant a rehearing for that purpose. If you grant the rehearing, well, let's say, just deal with this last point here. If you deny the motion for rehearing, then the person who's unhappy with your decision has a right to appeal to the Superior Court or to the Housing Appeals Board, if the Housing Appeals Board still exists after this legislative session. I'm not sure where that stands. But in any event, if the motion for rehearing is denied, then they can appeal. If you decide to hold a rehearing, again, your first decision is, do we grant or deny the rehearing? And if your decision is, yes, we grant the rehearing, then the case starts all over. You don't hold the rehearing then. You decide within 30 days after the motion is filed, you decide we're gonna grant the rehearing, and then they start all over. You schedule a new hearing. You send notices, publish the notice in the newspaper, send it to the interested parties, and basically it's a complete do-over. It's not limited to issues originally discussed. It's a whole new ballgame. As I mentioned, if a motion for rehearing is denied, someone may appeal. The party who filed the motion can appeal it to Superior Court within 30 days. If it involves housing or housing development, it can be appealed instead to the Housing Appeals Board. And as I mentioned, the governing body, the select board or the town or city council, has the authority to appeal on behalf of the city or town. That seems like something that wouldn't happen that often, but it actually is not that unusual. If the case is appealed, the board will have to compile the record, which is going to, the certified record includes everything, including the application, the correspondence, everything that was submitted, the minutes of the meeting, the written decisions, notices to make sure that it was clear that it was noticed properly. All of that stuff has to be compiled and filed um, with the Superior Court or with the Housing Appeals Board. If you get into that situation, you probably should be working with your attorney to make sure that everything is in there, because the decision, when this gets to the Superior Court or to the Housing Appeals Board, they're going to make a decision based only on the certified record. So you need to have everything in there to make sure they have everything in front of them. You don't want to be in a position of not having stuff in there that would support your decision. I'm on my last slide. So here are my concluding suggestions. Learn about the laws, the ordinances, and the rules. You're taking a good first step by coming to this conference, but I would assign as additional homework to read the applicable statutes, become familiar with your zoning ordinance. Some of your ordinances are 200 pages long. It's impossible for anyone to fully digest all that, but have a general familiarity with your ordinances and with your rules of procedure. Try as much as possible to stay up to date on changes in the law. Stay in touch with your other officials in town, building inspector, code enforcement officer, and keep in contact with your planning board. You do things separately, but it's useful to know what's going on each side and understand what each board's requirements and processes are. And that is the end. Looks like I have maybe 4 minutes left. If there are questions, Heather?
Yes, we do have a few questions we can go back to. A few questions were regarding conditions and so a question is, can conditions of a variance be modified years later? What would be the process if an applicant wants to modify conditions of a variance approval?
If you want to modify conditions after the fact, they're going to have to come back with a new application. And depending on I think it's probably going to have to be a whole new variance application, because you were granted a variance to do this thing subject to these conditions. And now you want to do, either you want to do a different thing or you want to do the same thing but with different conditions. I think that's going to have to be an entirely new variance application.
Right. Here's some questions about decisions. If a decision only existed in minutes, like for instance, if it was from the 1980s, can the administrator create a decision like a clerk's certificate sort of years later, if no written decision was ever done?
I would be reluctant to do that. I mean, the requirement of a written decision wasn't always there, the requirement of a separate written decision. And if you're talking about something from the 1980s, simply having it in the minutes probably satisfied legal requirements at the time. I'd be reluctant to try to create a decision now that documents what a decision 40 years ago was. But right. I think that may be the kind of thing, depends on the circumstances, and you may need to talk to your town attorney about that.
Right. A few more. I missed this one in conditions. The conditions only apply to variance appeals, correct? ZBA cannot put conditions on a special exception or equitable waivers.
No, I think you could. I mean, if one of the if one of the conditions of a special exception is that the use will not unduly impact neighboring properties, I think you could put a condition on there that use the example before of operating hours. It's granted as long as you're only open until 10 p.m. and you only have this kind of lighting, et cetera. Yeah, you could have a condition on a special exception.
Great, thank you. Here's a question about what's your recommendation for whether ZBA members can or should make their own personal drive-bys to the location of a property before voting? And this person says, obviously not as a group or with a quorum and not going on the private property.
You can do it. I would generally recommend against that. I think if people want to do a drive-by, what you actually should do it as a group with a quorum. But that if you do that, that is a public meeting, and you have to you have to allow the public to come along with you, and you do have. If the board decides we really need to see this property to understand what's going on here, you can say, yeah, we're going to schedule a site walk to do this, and a quorum of the board is going to be there. And if the property owner doesn't like that, too bad. The answer is, well, we need this information, and if you won't let us on the property to see what's going on, we don't have enough information to grant your variance or your special exception. So I think the better thing to do is, if you really need to do that, is to have the board do it as a public site walk.
Gotcha. And then we had a few questions. We're like a minute over, but I think we have time for these last few questions.
Okay.
And who pays for the cost of noticing a rehearing? And so someone noted that the ZBA itself can request a rehearing. And so a sort of follow-up question was, if the applicant is requesting the rehearing, would they pay for it? And if it's a ZBA who decides to rehear on their own initiative, does the ZBA bear the cost?
Oh, that's a good question. I would, unless someone in the afternoon session says something different, I haven't actually considered that question myself, but I would say, if the ZBA is deciding on its own initiative to hold a rehearing, I would recommend that the town pay for it. I wouldn't require the applicant to do it.
Great. I think we got, a written decision is only required for a land use permit, correct? It's not required for an appeal of an administrative decision?
No, for any decision, if there's an appeal of an administrative decision, there has to be a written decision by the board.
Great. Thank you. We're a few minutes over, but thank you so much, Cordell. This has been a super great session. We had a little bit more discussion going on in the chat about property visits, and we do have a Q&A session at the end of the webinars today. It's the last session, and so that might be a good topic for folks to bring up in that Q&A session. Thank you so much, Cordell. I'm going to take back control now, and we're going to go ahead and have a 15-minute break, and we will come back with our next session.
Okay.
Thank you so much. Thank you so much, Cordell.